Well, good morning, everyone. This is George Spees from the Pennsylvania Office of Open Records. I'd like to welcome you to this morning's webinar where we're going to be discussing basics of the Sunshine Act, also known as Pennsylvania's meeting law. A couple preliminaries to get out of the way here before we dive into the subject. First, if you've never participated in one of these webinars before, it essentially is a PowerPoint presentation with me talking in the background. The PowerPoint can be found on the OOR website under the Training tab, along with all of the PowerPoints that we use for our webinars and training sessions. You are welcome to download those and use them. Either, some folks like to follow along, or you can use it for future reference, or, if you have some colleagues who couldn't attend this morning and you want to give them an update on the topic, you can use the PowerPoints for that. They're easily accessible and you're welcome to them. Also, this session is being recorded. So again, like if you have a colleague who couldn't make it this morning, you can contact our office and you'll be provided with a link to a file sharing service that will give you access to the recording of this morning's session. If by some chance your computer security system doesn't allow access to file sharing, what you can do is send us a flash drive with a return stamped envelope and a note saying which session you'd like the recording of, and the staff here will be happy to copy that over and return the flash drive to you. Typically, the turnaround is about a week to get those flash drives back to you. If you have questions today, you're welcome to type them into the chat feature of the program. And I'm going to ask you two things here. First is that, the topic of this morning's webinar is the Sunshine Act. So let's keep our questions relevant to that. And secondly, if you can keep your questions fairly brief and concise, that would be helpful. Honestly, sometimes folks will type in several paragraphs, and it's just awkward for me to sit here and read through that while everyone else is waiting patiently. If it looks like you have something unusual or specific to your situation, we'll do one of two things. We'll wait until the end of the presentation, and I'll come back to your question, or we'll take the conversation offline. There is contact information on the screen right now, the office phone number, our website URL, which also has email addresses that you can use to contact the office. And, get back to us with your question, and we'll either the admin staff here will be able to address it, or if need be, we'll have one of the attorneys get back to you and try and get you steered in the right direction. Okay, so I think that takes care of all the preliminaries. Let's dive into the topic here, basics of the Sunshine Act, and like I said earlier, also known as Pennsylvania's meeting law. Okay, first off, we want to know why this is important. So I want to take just a moment here to read from the equivalent of the preamble to this law. And I only put this in here because I think it's important to understand what the Sunshine Act is all about, because, obviously there's a lot of assumptions, mistakenly, and, just misunderstandings about what the law is. But it is the right of the public to be present at all meetings of agencies and to witness the deliberation, policy formulation, and decision-making of agencies. It's vital to the enhancement and proper functioning of the democratic process that secrecy in public affairs undermines the faith of the public in government and the public's effectiveness in fulfilling its role in a democratic society. Okay, a very altruistic statement there, rather high level. But if you break it down, the purpose of the Sunshine Act is to allow the public to witness and participate in the workings of its government. And when we use the term agency there, it's in a generic sense. Commonwealth agencies, boards, authorities, and the like, as well as local agencies, meaning cities, boroughs, townships, authorities, school boards, and with school boards, a natural extension into charter schools and the like. So I like to say that the Sunshine Act is basically comprised of a three-legged stool. And when we are addressing inquiries here at the office, people will call in and say, is this legitimate? Does this represent a violation of the law? There are three main things that we look for to ensure that the Sunshine Act is being applied appropriately. The first is that advance notice given to the public of when the meeting is and how do we attend. And that part is important now with the online meetings that we see. How do I log into this meeting? How do I, get on with my computer or other device so that I can see and hear what my public officials are doing in the public meeting? Then they have the right to observe deliberations, and that can be either a live or an online setting. And then finally, does the public have the ability to comment prior to decisions that are made by the public officials in this public setting? Okay, so we're going to talk about all three here. But before we do that, we want to take a look at some basic issues. First offhand, who is covered? Well, we look to the law itself and have language in there about that the Sunshine Act applies to any state or local government body and all committees. Okay, now you can see we have committees italicized because this is always a subject of somewhat contention when it comes to trying to understand, is my committee subject to the Sunshine Act? So we look at the act itself, and I tell people, whenever you're trying to understand a law, you're going to come across sometimes vague language, sometimes conflicting language, and the like. Take a look at the definitions section, because that can oftentimes provide guidance and clarity as to what the rest of the law is saying. Look at the definition section and you'll gain probably a better understanding as to what the intent of the law is and how specific provisions within the law should be applied. So this issue of committees, with this slide, I'm going to solely take a look at what the law itself says, and then we're going to take a look at some case law. And honestly, there's not a lot of case law to support the Sunshine Act. It just doesn't, well, what I will say is that probably in the last 3 years, we've seen more case law on the Sunshine Act than ever before, and I think that's reflective of the public's desire to be better engaged with the workings of their local government. But overall, there isn't that much case law that we can fall back on to provide clarity with how the Sunshine Act is applied. But when it comes to this issue of committees, we are going to take a look at it. So what does the law say? Well, it kind of builds. And the first criteria is that it perform an essential government function. Okay, that can be a subjective phrase, but let's talk about that and try and sort it out here. An essential government function, it's kind of one of those deals where you know it when you see it. Okay, let's talk about what isn't. Okay, let's say that our township, within the township, there's a girls softball team, and they've won the state championship. Quite an accomplishment. So the supervisors decide that, it would be appropriate to have a celebration and recognition of this accomplishment. So let's have a parade, and then we'll have, some sort of public gathering, maybe a cookout or something like that, to celebrate what the girls have done. Okay, and then they appoint an ad hoc committee to organize the parade and the cookout. Okay, now as noted an accomplishment as this is, I think I could successfully argue that having a parade and a cookout is not an essential government function. And thus, the gatherings of that committee would not be subject to the Sunshine Act because it doesn't rise to the meeting this criteria. But let's change it up a little bit. Let's say now that there is a standing committee that meets periodically to review all of the township ordinances to ensure that the language is up to date, that they are relevant to current operations, that they're not in conflict with any state statutes or federal statutes, and they will come back and recommend to the supervisors as a body any changes that are needed to local ordinances to ensure that, in fact, they are up to date. Now there, I would argue that this is an essential government function, so the first test is met. And then we come up to the second step of the test, exercises authority to take official action. All right, again, a somewhat vague phrase and somewhat subjective, but yet, again, we look at the definitions in the Sunshine Act, and sure enough, there is one on official action. And one of the phrases, a key phrase within that definition, is making recommendations. So if your committee is performing an essential government function and it circles back and makes recommendations to the main elected board, then you would be meeting all of the facets of this test for whether or not your committee would be subject to sunshine. And you're thinking, well, what committee would not make recommendations back to the main board? You'd be surprised. There are some committees that are kind of independent, standalone, and they don't really have that much interaction with the elected board. Everything kind of works on their own. Also, there are some committees that are appointed simply to gather information. Don't come back to us with any recommendations. Just come back to us with the data that you have found concerning the issue that we have charged you with, okay? In that instance, they're not making any recommendations because as a fact-finding body, then they would not be subject to the Sunshine Act. So you can see how this kind of works. If they're performing an essential government function, and if they are exercising authority to take official action, and the definition of official action includes making recommendations back to the elected board, then your committee would be subject to the Sunshine Act, and you should open it up to public observation and participation. Okay, now let's take a look at case law like I promised here. And here we're looking at a decision from a couple decades ago, and it's called Ristow versus Casey. In that decision, the Pennsylvania Commonwealth Court tackled this issue, and they added some language in their decision that provides some further clarity on whether or not a committee would be subject to the act. And they ask a couple questions that require some thought and answer. First offhand, does your committee have decision-making authority? And this kind of goes back to the language in the law itself. And remember, decision-making authority includes making recommendations. But like I said, there are some committees that have no decision-making authority. They are purely fact-gathering or information gathering. So they would not meet the first step of this test. Okay, but let's say they do. Then we come up to the second step of the test. Are the members of the committee appointed by the board, and are they authorized to act on its behalf? Okay, well, you're going to think, well, what committee would not be appointed by the board? Interestingly, you can have some committees that are what I would couch as self-perpetuating. Public libraries are oftentimes a good example. And, libraries vary in their governance all across the state. But there are some that are what I would call independent and self-perpetuating, where let's say there is a vacancy on the library board, it is up to the remaining members of the library board to go out and find someone to take that seat. Your elected board really has no say in who the library board chooses to participate on the board from there on out. So there you would argue that the members are not appointed by the board and cannot act on behalf of the elected officials. But if they are, let's say it's like a public safety committee, okay? They're appointed by the supervisors or by council, and they're authorized to act on its behalf. They make decisions, they make recommendations and the like. Okay, they would meet the second step of this test. Then we come up to what I believe is the most important one. Are the recommendations being made by the committee pursuant to statute, ordinance, or regulatory authority, whereby the result is the enactment of laws, policies, or regulations? Okay, so let's break this down and try and explain it a little better here. The girls softball team, okay, the ad hoc committee to have a parade and a cookout. You're not going to find anything in statute or ordinance that requires that if the girls softball team wins the state championship, you must have a parade, okay? It's not supported by statute. Thus, the gatherings of that committee would not be subject to the Sunshine Act. But if the meetings of, or the gatherings of that committee are pursuant to statute, like a public safety committee, okay, there you're going to find statutes related to PEMA, the Emergency Management Agency, FEMA, the Federal Emergency Management Agency, and so forth, where, you know, it's required that government entities have a public safety presence, that any result of those gatherings are pursuant to statute. Thus, they would meet the third and most important element of this test as laid out in Ristell versus Casey. Okay, now, what if you're still unsure after all this? Well, obviously, with the Office of Open Records, we're responsible for transparency in government, and our position is going to be open up your meetings, okay? When in doubt, lean towards transparency. But there's also a practical element here, and I think, you know, you need to consider this strongly. There's what I call the straight face test, meaning that let's say you decide you're not going to open up your meeting, that for whatever reason you don't think it should be public. So someone takes exception to that, and they end up filing a complaint with your local court. And then the result is there's probably going to be a hearing where you have to go before a judge and explain with a straight face why you didn't open up your meeting to public scrutiny. Okay, now maybe you can do it. Maybe you have a perfectly sound reason for doing so. But if the judge disagrees, then there are sanctions that are going to make your life fairly uncomfortable for a while. You know, at the very least, there could be embarrassment for your agency. Worst case scenario is that you could end up paying fines, and we'll talk about that towards the end of the presentation. So on one hand, you open up your meeting, maybe it's inconvenient, maybe it's uncomfortable because it's a sensitive topic or whatever. But on the other hand, it could be very inconvenient to have to go to a hearing, make your case as to why you didn't open up a meeting. And, you know, if you had a judge disagree with you, and, you know, I don't know what your experience is, but my experience is if you catch a common pleas judge on a bad day, it could get worse for you. But anyway, you know, not only should you lean towards transparency because it's the right thing to do, but there may be a practical aspect as to why you should open up your meetings as well. Okay, moving on here. I think an important question to also answer is it a meeting? Because we will, here at the Office of Open Records, it's interesting how we've seen an increase in inquiries with the Sunshine Act over the years. I'm going to say probably 6 or 7 years ago, I went to our executive director and I said, look, you know, I'm noticing this trend where we're getting more and more questions about the Sunshine Act. And sure enough, that trend continued. And then when COVID hit, it skyrocketed to the point where it used to be about 10% of our inquiries were Sunshine Act. Now it's a strong 50%. So this is a question that often comes up. Is it in fact a meeting? Okay, and you can have a gathering of public officials where it is not a meeting per the definition of the Sunshine Act. So let's talk about a couple considerations here. The first question you have to answer is there a quorum? Meaning, is there a majority of public officials present so that they can in fact conduct official business? Now, members can phone in, but let's talk about this because this does not apply to first-class townships or to boroughs because their codes, the first-class township code and the borough code, require that a quorum of the board be physically present in order to conduct official business. Now, any member above the quorum or beyond the quorum can then phone in. Okay, but it must be a direct connection, meaning that the person phoning in has to be able to hear everyone physically present at the meeting, and everyone physically present at the meeting has to be able to hear the person phoning in. And, that's easy enough done with the online platforms or like a conference call or whatever. What you cannot do is have someone sitting at the table with a cell phone up to their ear relaying messages back and forth. Okay, that would not be consistent with the provisions of the law and case law. Okay, then the next question we need to answer, is there deliberation? We go back to the law itself, and there's a definition of deliberation. And to paraphrase, it's basically any conversation that can lead to a decision. It's not that there must be a decision. It's just that there is the possibility of a decision being made. Sometimes the decision is not to make any decisions, not to do anything. But if there is discussion about the business of the board and its jurisdiction, that constitutes deliberation. Okay, so think about this. You could have, and this is a common question that we get. Hey, the other day, I went to the local restaurant for breakfast, and 3 of the township supervisors were sitting in one of the booths. Isn't that illegal? Well, if they're not talking about the business of the township, no, it's not. They can get together and, talk about the weather. They can talk about their families or whatever. As long as they're not discussing the business of the township, then it's not deliberation, and that gathering is okay. All right, then the next question that we need to answer, is there decision-making? Typically, in the context of the Sunshine Act, decision-making is a vote. Are they taking a vote on something? Okay, and if they're not taking a vote, if there's no deliberation, then we're okay. And then finally, I just want to caution you about email meetings. Sometimes you get, a new board seated, and maybe the president is, has a business background, and he's familiar with email and how it's such an easy and efficient way to get things done. Well, let's just resolve this issue with a couple emails that we're going to send around. If, in fact, the emails involve policy decisions made by the governing body, those emails are not taking place in a public setting, and that would be inconsistent with the Sunshine Act and potentially would be a violation. Even if you're not emailing a quorum, let's say the email is just going one at a time. If you have, what we'll call a de facto quorum, ultimately everyone gets the same message, and there is deliberation about this message, that is deliberation, and it would be a violation of the act. So I just want to caution you, you can use email for administrative level discussions, but you cannot use it for policy issues that normally would transpire in a public meeting. Okay, what's the distinction? Well, let's say that last month, the board voted in a public setting on a particular course of action. But now we need to work out the details. Let me just pull, okay, an example. The board voted to expend $250,000 on street paving this year. Okay, that was the vote, it passed. Okay, but now we need to decide which streets are going to get paved. Okay, the decision has already been made by vote that we're going to pave streets. Now, the details, the administrative component to that vote can be worked out outside of the public eye. And in this particular instance, it would be okay to use email to do that. Okay, I hope you see the distinction. The policy decision has been made. The administrative decisions have not been made, but because the policy decision was made, the administrative decisions can take place outside of the public eye and would not be subject to the provisions of the Sunshine Act. Okay, hopefully I've explained that distinction clearly. Okay, what is not a meeting? Well, yeah, I just talked about one particular example, administrative action versus agency business. If the decision's been made and now you have to work out the details, you can have those gatherings outside of the public eye. Work sessions, conferences, and retreats. Work sessions is a good one. School districts, I think, are the best example, where they will have a monthly business meeting that takes place in public, but many school districts will also have a monthly work session. Communication is one way, meaning that typically the superintendent or staff will stand up before the board and provide information on current initiatives, items of import that the board, it's important for them to be educated so that they can make an informed decision when it comes time to vote. So the individual board members can ask questions of staff, but what cannot happen is the board members cannot discuss the merits of the information amongst themselves, because that becomes deliberation. And as we learned earlier, deliberation must take place in public. So you can have this give and take with staff. It's just that the board members cannot discuss the information amongst themselves. In the same way for conferences, many boards will go to conferences periodically to, learn about the latest technology or policies or trends or best practices that are happening. It's just that they need to be careful not to talk about agency business as a board at these retreats. So there's no deliberation and there's no decision making, kind of like that breakfast meeting that I was talking about. Actually, I should use the term breakfast gathering, because it's not a meeting, because there's no deliberation, no decision making taking place. Okay. Now, with work sessions, though, I do want to caution you, because this comes up periodically. There are some school boards, and I'm not picking on school boards per se, it's just that I know that this happens, where they will couch their gathering as a work session. They advertise it, they allow the public to be present, and they allow the public to comment on issues, but they still call it a work session. And occasionally they will vote on policy matters. My take on this is that, and there's no court decision to support this, this is simply my take, is that when you call it a work session as opposed to a business meeting, you're creating the expectation for the public that no decisions are going to be made. So if you do make a decision, the optics are you're kind of sneaking something through, and that's going to create problems for you. So be careful as to what business, if any, transpires during a work session. Even though you may have met the specific provisions of the Sunshine Act, the fact that you're calling it a work session creates these expectations that you're not going to be conducting business. So if you do, you could find yourselves, again, having to pass that straight face test that I was talking about earlier. Okay, moving on. Let's talk about public notice, the first leg of the stool. Okay, under the Sunshine Act, you're required to have 3 days advance notice of the first regular meeting of the year. Typically, it's the calendar year as determined by the specific code that governs your jurisdiction. Okay, so you have, basically it's called an organization meeting. So at least 3 days in advance, you have to advertise in a paid newspaper of general circulation that you're having the organizational meeting, along with the dates of all subsequent meetings that you expect to have during the calendar year. Now, newspaper articles, or what are known as puff pieces, don't count. It has to be one of those legal notices. Having it on your website is a good thing, okay? If you have a website, a Facebook presence, any other social media, having the dates of your meetings is a good thing, but it does not meet the provision as required in the Sunshine Act. It must be a legal notice and a paid newspaper of general circulation for your jurisdiction. And those free sale circulars, and they pay me to talk, that fill up your mailbox every week, they don't count either because they're free. You don't pay for those. Now, I am the first to recognize, and our office is with this, in that we are witnessing structural changes in the news media business, where this is becoming more and more difficult. But until the law is changed, this is what we're faced with, okay? If you have concerns about this, I suggest that you reach out to your state legislator, express your concerns, and see if there's any initiative to change this provision of the Sunshine Act. Okay, enough said about that. Now, what if you meet for your organizational meeting and you realize there's a conflict and it's not going to work to meet like the first Tuesday of every month? We need to change it to the second Tuesday. Well, then you would need to run a second legal notice informing the public that you're changing the regular dates of the meetings. Okay, and that would satisfy the legal requirements. Okay, and then everything also needs to be posted at the meeting site. So if you have like a regular meeting room or conference room or something, there would be some sort of physical posting that these are when we're going to have the regular business meetings for the board. Okay, you can also have special meetings. Now, a special meeting would not be previously scheduled. Something has come up where we cannot wait until next month. We've got some business that must be dealt with before the next regular scheduled meeting. So we have a special meeting, and then the requirement of the Sunshine Act is the same for public notice, except that now we're down to 24 hours advance notice rather than 72. And by the way, you need to also take into account the publishing cycle for the newspapers, okay, to make sure that it gets published 24 hours in advance of the special meeting. And then you can also have emergency meetings. And an emergency meeting is when, something has come up that we cannot wait to advertise and have a public meeting. I use a snowplow example, okay? We're a small borough, we have one snowplow. It's an old plow, and it's, had a lot of repairs, and it just broke down. The parts are no longer available, and the forecast, interestingly, is calling for a storm. We've got to get a new plow, and there's one sitting down the road, brand new. We can get a good price on it. We need to go vote so that we can purchase this snowplow. Okay, bona fide emergency. Okay, we didn't see the breakdown coming. We need to buy the plow, so we have an emergency meeting outside of the public eye where we vote to approve the purchase, okay? That is a good reason for an emergency meeting. Now, you cannot create your emergency, meaning that let's wait until a good time to vote on this sensitive issue that has everybody up in arms. We'll quietly have an emergency meeting, and then we'll vote for it, and then that'll be it. All right. If you try to outthink the Sunshine Act, or any law for that matter, sooner or later you're going to get bit. And this is another one of those situations where the straight face test comes into play. You have an emergency meeting for something that may not have really been an emergency. Are you willing to stand before a judge and explain why you thought the circumstances were an emergency when in fact the facts may indicate otherwise? Okay, just be careful. Do not try to outsmart the Sunshine Act, because, you know, it could get ugly. Okay, and then if you have to cancel a meeting, like a snow emergency, or maybe you couldn't get a quorum due to illness or whatever, there's nothing in the Sunshine Act that requires any notification of a cancellation. But, you know, if you can use your social media to get the word out that, hey, we're canceling tonight's meeting, you should. Okay, it's just good public service, because even with a snowstorm, there are those people who will go out and drive down to Borough Hall or the Township Building expecting there to be a public meeting, and they show up and it's crickets. You know, all the lights are out and no one's there. Okay, try to let people know, you know, through news media, through your websites and the like, hey, tonight's meeting is canceled due to the snowstorm or lack of a quorum or whatever. Oops, I'm sorry, I went way too far. Let me back up here. Sorry about this. Okay, there we go. Hit the wrong button. Okay, agendas. There is it's not new anymore. It's probably 2 years now, where the legislature passed an agenda requirement provision for the Sunshine Act with public meetings. Essentially, what this says is that all agencies must post an agenda of anticipated business or anticipated deliberation prior to the meeting happening, and there's a 24-hour window. Okay, so let me walk you through the timeline here. Prior to 24 hours, you can do anything you want to as far as an agenda is concerned. You can, you know, make whatever changes are required. 24 hours prior to when the meeting is going to be convened, at that point, the agenda must be posted, okay? And it ends up being posted on your website. If you use Facebook rather than a website, then it has to be posted to your Facebook page. It has to be posted at your agency offices. It has to be posted at your meeting site. And then you also have to have copies available to the public to hand out when they come to the public meeting of the agenda. Okay. If there are any changes in this 24-hour window, they can only be de minimis, meaning that you cannot make any changes that would result in a contract or any significant expenditures. Okay. Once the meeting is convened, then you can make some changes. And I think I'm probably getting a slide ahead of me here. But the agenda requirement would apply to regular and special meetings. It would not include those work sessions, conferences, or executive sessions, because number one, there's no deliberation. Number two, there's no decision making, except for executive sessions. And I'm going to talk about that here in a couple of minutes. Okay, so use your websites as posting mechanisms for your agenda as well as the physical requirements. Okay. Yeah. So walking through this timeline, like I said, before the meeting, it's an open book. You can make whatever changes until 24 hours. Then any changes that you need to make to the agenda are de minimis. No expenditure of funds, no entering in any contracts. Okay, so once the meeting is convened, though, you can change the agenda. It's just that there are some very distinct steps that need to be satisfied here. Okay, first offhand, if the public, you know, through public comment says you should be changing the agenda, you're not under any requirement to do so. the board can defer that for a future meeting if they decide that that's how they want to deal with it. But if the board does decide, hey, we need to change the agenda, let's say through discussion something comes up and it's decided that they want to deliberate on something and they want to vote on something, then what happens is, first offhand, the board must vote to change the agenda by majority vote, okay? And then that gets recorded in the minutes as official action. So that's the first step. Then the reason for the change must be announced to the public. We are adding this to the agenda because, okay, and then you go through that. And then once it's added to the agenda by majority vote, then you can have deliberation and a vote on that issue. And, you know, maybe because of the way the deliberation goes, you decide you're not going to vote on it. You're not going to do anything. Well, there's still that requirement that you added it to your agenda because you are deliberating on it, okay? But remember, deliberation is any discussion that could lead to a vote. So that would represent a change to the agenda because you are deliberating on this issue, okay? And then if you did decide to change the agenda through the steps that we just delineated here, the amended agenda must be posted within 24 hours once the meeting has adjourned, okay? And posting would be on your website, the physical location of the meeting, the business offices, and the like. Now, the question comes up, okay, well, how long do we need to have the posting up? There's nothing in the Sunshine Act, okay? So this is George logic coming through here. There's nothing in the Act, there's no case law. But most of the timeframes related to the agenda requirement are 24 hours. So I'm going to go out on a limb here and say your amended agenda must be posted at least 24 hours. It's a 24-hour window after the meeting has adjourned. So you would leave it up for at least 24 hours once it's posted, okay? Now, caveat, a judge at some future date may disagree, and he may say, well, George is wrong. But the judge also might say, yeah, this George is a pretty smart guy. Yeah, it makes sense to me. Who knows? But we get asked the question, that's usually the answer that I give. Okay, and then remember that your minutes, you're required to keep minutes. Both that provision is in the Sunshine Act, plus it's also in the codes, the state codes that govern your jurisdiction, that you have to keep minutes. Well, the minutes must reflect the change that you made to the agenda, and it would reflect usually the two votes. The first one would be the vote to amend the agenda. The second one would be whatever vote would be connected to the item that you added to the agenda, okay? So that we can kind of figure out what happened based on a reading of your minutes, which is the official record of the public business meeting. Okay, moving on. Let's talk about public comment. Now, public comment only applies to local agencies. It does not apply to state agencies. And this is based not on what the Sunshine Act says, but what the Sunshine Act doesn't say. And it's interesting because when you get to that public comment provision, it only refers to local agencies. And even then, the language is somewhat obtuse, but just keep that in mind if you happen to be listening today from a state agency. But let's talk about this for local agencies. First offhand, commenters can be limited to residents and taxpayers of the jurisdiction. So that let's say you're a township and you're having your business meeting and someone from an adjoining township comes in and signs up for public comment, you can prevent them from making public comment, okay? It's in the law. Then there's language that says the public has the right to comment on issues that are or may be before the board before any pertinent votes, okay? Most important thing is that, yeah, comment takes place before the board votes on something. Okay, but then there's this issue, that word may is in there, which kind of opens things up, because ideally you would want comment to be about whatever the board is discussing. But because that word may is in there, Fred can come in and complain about the potholes on his street, even though potholes aren't on the agenda. All right, so I'll talk about this with the best practice that many jurisdictions are using. Okay, and then the board can establish reasonable rules for public comment, such as time limits. We're in our meeting rules, we allow everyone for public comment 3 minutes time. All right. However, because that word reasonable in there, you can set the rules aside given extenuating circumstances. Let's say that there is a big issue that has a lot of public interest coming up for vote tonight. So we're going to give everybody 5 minutes instead of 3 minutes. Okay, we're going to set the rules aside or amend the rules to allow 5 minutes. Or let's say that there's a big issue, a lot of public interest, and a group comes in, they're all wearing the same t-shirts, and they all sign up for public comment. The president of the board can approach them and say, look, I've got a suspicion that every one of you is going to be saying pretty much the same thing. In order to save time here, how about you appoint a spokesperson? And we'll give your spokesperson 10 minutes to make sure everything is covered. Okay, that way there won't be a lot of repetition. We won't be here till midnight, and your group will be duly represented. What do you say? You agree to it? They agree. Okay, a reasonable rule. And and then you can put stuff about no personal attacks, et cetera, et cetera. Just be careful with how you deal with this, because there is actually some federal law. Gosh, it's coming up on, I think, 2 years now, where some school districts got themselves into trouble where during public comment, if somebody would say something that the school board felt wasn't relevant to discussion, they would cut that person off and end their public comment. Well, they turned around and filed a suit in federal court claiming a violation of their First Amendment rights. And last time I checked, at least at the first level, the courts agreed with them. And they said the school district had violated this person's right to free speech. So be very careful about shutting people down during public comment. Again, it's somewhat subjective. You don't want to have to put up with abuse, okay? But at the same token, people have a right to address their public officials in a public setting, okay? That's the whole purpose of the Sunshine Act, when we go back to that preamble that I had with the first slide. Okay, and then we have specific versus general comment. Okay, now this is not in the Sunshine Act, but rather this is a practice that more and more municipalities are embracing to deal with this issue of generic comments, okay? And what they do is that prior to a vote taking place, they allow public comment on the matter at hand, okay? We're getting ready to vote on this bond issue, so anyone having public comment on the bond issue may now speak. Okay, and then at the end of the night, anyone having public comment of a general nature may now address the board. Okay, and that way the two are separated. Again, I want to reiterate, no legal requirement to do this. Okay, it was brought to our attention years ago that a couple townships, boroughs, and the like had adopted this practice, and it's working out for them. So I just want to make a point, to spread the word that maybe you want to consider this. You don't have to, but maybe you want to consider it. Okay, moving on here. Let's talk about executive sessions, kind of shifting gears a little bit. An executive session is a meeting of the board that can occur outside of the public eye due to the sensitive nature of the discussions. Now, An executive session can be held before, during, or after an open meeting, or they can announce it for some future time. As long as the public is made aware of the fact that there's going to be an executive session and the reason for that executive session. Now, the reason must be complete. Okay, for instance, and this is case law backing this up, and the case is City of Reading versus the Reading Eagle. Reading Eagle is the local newspaper. Basically, the president of council would stand up and say, we're going into executive session for personnel reasons or for legal reasons. Okay, the paper filed suit said, that's not good enough. You need to tell us more why you're going into executive session. The courts agreed. And in this case, there's language in there that, again, to paraphrase, they're basically saying that you need to give the public sufficient reason as to why you're going into executive session, why, in essence, you're invoking secrecy so that they are satisfied it's for a legitimate reason. Again, it gets somewhat subjective, but you have to weigh privacy considerations versus the compelling reason of the public's right to witness the deliberation of their public officials. Okay, so you can usually find a balance. We're going into executive session for personnel reasons because we have to determine whether or not one of our employees violated a work rule. Or we're going into executive sessions for legal reasons to discuss our strategy with this case that's been filed in the Court of Common Pleas, and the docket number is, or the case title is XYZ Company versus our borough. Okay, so that the public is aware that there is an outstanding court case, and there are legitimate reasons as to why you're going into executive session. Now, with executive session, there's no requirement for minutes, but if you do keep minutes, they are exempt from disclosure under the Pennsylvania Right to Know law. Now, in executive session, you can deliberate, you can discuss the sensitive issues at hand, but you cannot make a decision in executive session. Any subsequent decision must be made in a public session. Now, you can poll the members and say, you know, what do you think of this? How's this going to go? Okay, but the official action must take place once the executive session has adjourned and you've reconvened in public session. So let's say you've decided we're going to suspend this employee for 3 days based on what was presented in executive session. Okay, so you would adjourn the executive session, come out into public session, and then take an official vote to suspend this employee for 3 work days. Okay, so the vote must occur in a public session. Now, reasons for executive sessions. Personnel matters such as hiring, firing, discipline. Personnel matters must involve a specific position or a specific employee. You cannot go into executive session to discuss personnel policy, like we're now going to allow X number of sick days per employee or something like that. Okay, that's policy related, not position or employee related. That must occur in a public setting. Okay, discussing labor negotiations makes sense. Considering the purchasing, leasing, or selling of property. Okay, now if you look at the law, it does not say selling, but there is an unwritten Commonwealth Court or unpublished Commonwealth Court decision. It is written where the court decided selling is a natural extension of this provision within the Sunshine Act. So yeah, you can go into executive session to discuss the selling of property. Consulting with counsel, your solicitor about litigation. Avoid violating privilege or confidentiality. Okay, privilege would typically be attorney-client privilege. Let's say you're having a meeting, one of the board members says something and your solicitor's eyes get real big and they say, we need to go into executive session right now. Okay, yeah, It's because your solicitor wants to provide legal guidance to the board. They can do that in executive session because it falls under attorney-client privilege, that communication. Discussing university admission standards, I don't know. I wasn't around in the 1950s when they put this in the law. Or to discuss emergency preparedness, which would be something like Homeland Security, your emergency management plan as required by law through FEMA or PEMA. That kind of stuff can be discussed in executive session outside of the public eye. Okay, those would be the reasons for meeting in secret. Okay, violations. What if someone feels your board has violated the Sunshine Act? Well, first, during a meeting, they are allowed to stand up and address the board as the perceived violation occurs. I think you violated the Sunshine Act just now because, okay? And then they sit down. That's the end of it. Okay, now the board, let's say they agree with what's been brought to their attention. They can say, oh yeah, we forgot to take this vote, or that vote was improper. They can cure it right then and there by saying, okay, we will take the vote right now. Okay, so they can cure the violation that would have occurred. But let's say they disagree with the member of the public. No, we don't think we violated the Sunshine Act. Okay, so they go on with their business. The public can file a complaint, or basically they seek legal relief with their county court of common pleas within 30 days of the meeting. Okay, and when we say legal relief, it could be declaratory relief, an injunction, whatever. Okay, it's specific to whatever happened. And if they think there's any criminal culpability, they can also approach the district attorney. The district attorney will investigate, or if they decide to, they will investigate any criminal aspect to what occurred, but they will not rule on Sunshine Act violations. That would be a civil matter to be determined by the judge, okay? And then the judge, typically they would have a hearing, bring the parties in, and then you face that straight face test that I talked about. And if the judge determines that there is a violation, they have a pretty broad degree of discretion in what they can do. They can simply say to the board, don't do it again, okay? Or they can say, I'm going to void this vote, or they can void an entire meeting, which they've done recently. Another thing that's come up in recent years is they require Sunshine Act training for members of the board. And then the worst case scenario is that they can sanction the board members with fines. And it's up to $1,000 for the first violation, up to $2,000 for the second violation. The fines are paid by the board members. An agency cannot pay the fines on behalf of the board members, okay? Comes out of your own pocket. Okay, so you need to be careful about this. As a public official, you bear this burden, okay? And it could get painful. Yeah, there's not a lot of fines. I don't want to scare everybody into thinking, but it happens periodically. The big trend that I've seen is the whole training thing. Judges have kind of latched onto this. And people, when they file suit, they say, the remedy is to get our public officials trained. All right, so the judge agrees with that, and that's the basically the sentence or the settlement that they come up with. Okay, so that seems to be an interesting facet to what we're seeing here with the Sunshine Act. Okay, we're near the end here. Just some miscellaneous things as we're wrapping up. Yeah, you are required to produce meeting minutes, recording what board members were present, and the votes, were they, up or down? If there is a roll call vote, then you need to record how each member voted, okay, in the minutes. And remember, minutes are clearly a public record, subject to disclosure under the open records law, the right to know law. Now, the public can record public meetings, and they do not have to tell you that they're doing that. Okay, there's no requirement that they announce, hey, I'm recording your meeting here. And it's not a violation of the Sunshine Act nor the Pennsylvania wiretap law. Okay, there's a provision in there that allows this. What I recommend is at the beginning of the meeting that the chairperson, when they're going through their welcoming statements, that they include, and by the way, there's no expectation of privacy in this public meeting. It is possible you're being recorded by a member of the public. And if the jurisdiction, if the agency itself is recording the meeting, then they're entitled to do that, and many do for purposes of keeping the minutes and so forth. That recording that is in possession of the agency is also a public record, subject to disclosure under the right to know law. Okay, now the recording and the minutes are two different things. Okay, a recording is not the minutes. Okay, but both are considered public records. Alrighty, so we are now at the end of our presentation. Okay, can you send a copy of this recording to us? Yeah, Diana, at the beginning, if you missed it, this session has been recorded, and usually what happens is that contact our admin staff, send them an email saying that you would like a copy of this recording, and they will provide you with a link to a file sharing service. And that'll get you, you're more than welcome then to share the recording. If by chance your security system does not allow access to file sharing, you can send a flash drive into our office with a note and a self-addressed stamped envelope to return it. And the staff here will make a copy for you. I can't do it. I'm just I'm a consultant at this point, so I don't have access to it. Specific email address you'll find on our website, and it's readily available. Or feel free to call the office, and they'll steer you in the right direction. But yeah, you can get easy access to the recording of this session. Which brings us to the final slide here, where we are going to talk about resources here real quick. Go to our website that I just mentioned. It is one of the best, well, what the heck, it is the best government website you're ever going to run across. It has all kinds of resources that give you information on Pennsylvania's right to know law, as well as a page dedicated to the Sunshine Act. FAQs, court language, stuff in there that you'll find very useful, guides for citizens, guides for agencies. There is a final determinations database if you're really interested in the right to know law. You'll also find references to court cases about the Sunshine Act. If you're interested in further training, you can reach out to our office, and one of our staff will be more than happy to address you and see what we can do to help you out. Okay, questions come up. We have a policy to delete the recording once the minutes are approved and is no longer available. Should this policy be changed? Not necessarily, Linda. Under the right to know law, the recording remains a public record as long as the agency is in possession of it. And if you look at, I believe it's the Municipal Records Act, it says that you hold on to recordings as long as you have an administrative need to do so. Okay, so if once the minutes have been approved, you no longer have a need to have the recording, technically you can erase them, and many agencies will do that. Many other agencies will hold on to the recordings. They'll put the recordings on their websites, or they'll stream them. But that's up to you as to how you want to handle it. But from a legal perspective, maybe you want to confirm this with your solicitor, but I believe you're on solid ground where you can delete the recording once you've approved the minutes. Okay? Hey, if there's any other questions, please get them in. If once we end the session, you have further questions, go to the website, go to the email addresses that are there, and feel free to email in your questions because they're administrative staff that they spend all day. Okay, profanity at public meetings by the public. Okay, I'm going to assume that are you asking, is that allowed? No. However, usually what happens is that your board will have um, um, rules of, what do I want to say? Rules for the administration of public meetings. And if you have in there that profanity by a member of the public, or for that matter, by a member of the board, will not be tolerated and could result in removal, okay, then there, in essence, you have a legal basis for whatever action you deem necessary that the board take if someone should get out of hand. Now, my recommendation is if things start getting heated, and let's say there's bad language, give the person a warning. And if it looks like things are still hot, maybe take a short recess to let tempers cool down a little bit. And then once they have, come back, and start over again. Now, if things are out of hand, before you start calling in the police to remove people, maybe you need to decide, well, let's, recess for tonight and we'll re-adjourn later and hopefully, we can sort through things and get things calmed down. But again, that's up to you. Okay, the proper way to adjourn a public meeting, well, you do it by vote. Is there a motion to adjourn the meeting? Do I have a second? All in favor of adjournment, signify by saying aye, or my favorite is signify by standing up and walking out that door. But there's it depends on the rules of your meeting. Typically, most agencies follow Robert's Rules of Order, but there are other rules, and you can amend Robert's Rules of Order for your specific agency. And you can set the rules aside by majority vote. Okay, it just depends on the specific situation that you're facing. But I think the main concern, Isaac, that you're raising is profanity. And no, you shouldn't have to put up with abuse. But if you have it specified beforehand that we're not going to tolerate this and you get one warning and then we ask you to leave, or we have the police remove you, then everyone is put on notice as to what the expectations are. Okay, so I think you raise a very good point, and I'm glad you did, because it happens more often than we'd like with people getting heated and not acting the way they should. Okay, so thanks, folks, for all your questions and your participation here today. Like I said, if you have any further questions, feel free to email the office. We'll be back in 2 weeks with another webinar. Everyone stay safe out there with the storm that's coming across the state right now, and stay healthy, and we'll look forward to our next webinar. Take care, folks. Why did I can find my cursor to log off? Where's it at? There we go.